Yes, I can say the 2022 Electoral Act made some impact in our electoral dispute. For instance, in the Electoral Act of 2010, repeal, under Section 29 of that Act, provides that any person who feels that a candidate has submitted a forged or false document can approach the courts for redress. In that Electoral Act, it is open to every person, anybody, whether you are a member of any political party, whether you are a member of that political party, whether you are an aspirant or not. The moment you feel that a candidate in an election has submitted a forged document under Section 29(5) of the Electoral Act 2010 as repealed, can approach the court. And under that act, the courts referred to there are FCT High Court, High Court of the State, or Federal High Court. But in the 2022 Electoral Act, there is a paradigm shift from anyone and everyone to only the aspirant. So in the 2022 Electoral Act, for you to complain in court, for you to have what we call the local standing to complain in court against a person who has submitted a forged document or false information, you must be an aspirant. So it has limited those that can approach court for redress. And under Section 84, sub 12, 13, 14, you must be an aspirant to complain. This is one of the innovations that has helped in limiting number of cases, sometimes frivolous cases, that are filed in pre-election matters. Now, apart from that, under Section 137 of this same Act, it provides that where documents are tendered, certified through copy or original document tender, and there is manifest on the face of that document that there is non-compliance, you don't need to call oral evidence. And that provision was interpreted by the Supreme Court in the case of Oyetola against INEC. Oyetola against INEC is the locus classicus in the 2022 Electoral Act. And recently, the Court of Appeal sitting in Abuja, in the case of Reverend Johanna against Senator Cliff, interpreted that provision that when it is clear on the face of the document tendered by any party, certified by INEC, or the original, that there is non-compliance, you don't need to call oral evidence. So when you take some of these provisions into consideration, you will be safe to say that the 2022 Electoral Act has made some improvement in the resolution of our electoral disputes.
Very well said, sir. So have any of these decisions contributed anything to a new election jurisprudence?
Yes, of course they have. I just cited the case of Oyetola against INEC, where the Supreme Court, I think per Jaro JSC, interpreted Section 137. And if that provision is to be taken and to be bound, that decision is to be followed by every other court. Some of the matters in court that the complaint are purely based on non-compliance with the provisions of the Electoral Act. You don't require numerous witnesses to prove your case. For instance, when on the face of the result, it is altered, do you need to call oral evidence to say that that result is altered? If you call oral evidence, you call to say what? That this result is altered or that the result is not altered. The purpose and the purpose of Section 137 is to alleviate some of these issues, alienate some of this, and then it fast-track the hearing of the matter. It simplifies the hearing of post-election matters. If the courts are to follow and apply the provision of Section 137 to the latter, there will be no need to call numerous witnesses to prove non-compliance, especially when on the face of the document, you can see that there is non-compliance that the petitioner is complaining about.
So from the decisions rendered by the court so far, are you willing to suggest any further amendments with current?
Of course. I have serious grievance with the interpretation of issue of subpoena witnesses. Before now, authorities are to the effect that a subpoena witness does not need a witness statement to testify in court. And the reason is very simple. While you are filing your petition, you don't know who will be the supreme witness. And in most cases, these supreme witnesses are INEC witnesses. You are complaining against the decision or return made by INEC, and you are subpoenaing INEC to come and tender a document. It is impossible to get a witness statement from INEC or INEC staff to be filed along with your petition. It is impossible. Again, in some instances, you are subpoenaing official witnesses from government agencies whom you don't know, whom you don't even, you don't know the modus operandi of the organization. So how possible is it to get a witness statement from these people? And that is the reason behind the decisions like Lasun against Owoyemi, Patricia Ete, Kodla and Bashir, where the court then said, look, when it comes to supreme witnesses, it does not require filing of witness statement. But the current trend and the current position of the law, stemming from the decision in Ararume and INEC, that for every supreme witness in election petition, you must file his witness statement. And that has constituted a clog in prosecuting petition. If you have not prosecuted a petition before, you will not know how difficult it is to prosecute a petition. And for you to be expected to file a witness statement of an adverse party, honestly, to me, it is an impossible task. So my advice to the legislators, because that provision and that interpretation is affecting all of us, it's affecting everybody, is to amend the Electoral Act to give room to supreme witnesses to testify without witness statement on oath. So that is a strong recommendation I will make for amendment of the Electoral Act in subsequent amendment.
Very well said. So can you kindly assess the decision of the president? Okay, so something happened, right? The two appeals are there that came up on that was on Tuesday, where the Court of Appeal sacked all the PDP lawmakers. Now, one of the reasons that the court gave was that the PDP lawmakers did not obey the court order of the Protested High Court, which has said that they had illegal congress. Don't forget that the Supreme Court has said such issues are internal affairs of the party. They cannot be part of it without judgment over time. Now, it seems to be worrisome to me. I don't know from your own perspective. What do you think? Do you understand the question?
Well, in answering that question, I must be careful.
Okay.
In the sense that I am not part of any of the appeals on Plateau. I also have not read the judgments of any of the cases or appeals on Plateau. The same way you read on social media is the same way I have read. That the court sacked all these legislators because their political party, the PDP, did not comply with the judgment of court. If you don't have the fact of a case, it will be premature and for you to comment. All I know is that for every disobedience to court order, there is a consequence. So if the court said the consequence of disobeying the court order is nullification of your election, well, that is the decision of the court. I am not part of that cases, so I'm not competent to comment on them.
Okay, so finally, there have been calls that the office of the